perspective. And so I appreciate you making the time for us to have a conference. Also, just so you know, I've got a young woman here named Betsy Gould who is she just graduated from FSU. She's thinking about going to law school. So let's show her the good part, the fun part of law school, and see if we can still persuade her that she wants to be a lawyer. So there are two reasons I wanted to have this conference. One is that Mr. Tyson requested that we have a scheduling conference because of the expedited or the statutory language that understands that these might need to be handled in some sort of expedited manner. And so we needed to have that conversation. Before we start that conversation, though, Ms. Oinonen mentioned in an email, sort of in passing, hey, there's some people that maybe have looked at statutes and they think maybe you should remove yourself from the case. I'm not really sure if I know the answer, so I'll just defer to the court. And so some variation of that, not a direct quote. But so I did take a look at it because I have had cases where there were election challenges in Fulton County that ultimately were assigned outside the county. It's not really a recusal. It's more of a procedure that is prescribed by OCGA 24CV007332. Now, here's the rub, and this is the conversation I wanted to have with y'all. Two things that I am hoping that y'all can provide me with some insight about. Number one is, I think the most obvious, setting aside the really confusing, unnecessarily complicated language of subsection C of that statute, which Fulton County also adds to the complication because we're our own county, we're our own district or circuit, and we are our own district. Whereas clearly, I think what C is directed to is multi-county, multi-circuit districts, et cetera. So setting that aside for a moment, because this is a statewide issue, my concern, and I welcome y'all's thoughts, that's the purpose of this conference, is that if I were to follow the procedure, or if I were to point out to my chief judge, who in the 5th District, Atlanta Circuit, is also the administrative judge for purposes of subsection C, that this procedure has not yet been followed and needs to be followed because the statute is written in the directive form. It is written as a shall. It would get assigned probably to Clayton or DeKalb. Can't swear to that, but that's usually where these things go in terms of our administrative procedures. But it doesn't really matter where it goes, because aren't they going to then have the same problem? Which is that ultimately this is a statewide issue. So that's my first question. My second question is that subsection A of that provision indicates that it uses the word defendant, but I think it clearly must mean the word candidate, because it talks about where the candidate with where the defendant with the most votes resides, et cetera. But so obviously I understand the idea of, having a defendant that ties jurisdiction to a particular place, and then, having pulling in a non-resident defendant from another jurisdiction because you have one here. And here you have sued the Fulton County Board of Elections, which clearly is venued in Fulton County. But if defendant in subsection A actually means candidate, then do we need to have a conversation about where Mr. Davis resides for purposes of this litigation? Because my understanding is that he has been served at the place he claims as his residence, which is in Walker County, Georgia. So those are the two reasons that I wanted to have this conversation. I'll throw open the floor and perhaps start with Ms. Oinonen, because I think before we get to any other issue regarding scheduling, we really do need to figure out what we're going to do about the applicability or lack of applicability or whatever of OCGA 21-2-523. Ms. Oinonen?
Thank you, Judge Krause. And by the way, I haven't left for Philadelphia yet. I'm leaving tomorrow, so I'm not missing any conference. So I appreciate you accommodating me. So everything that you said made perfect sense to me, the way that you were kind of interpreting 523. that's how I read it. But then I talked to our various team of election legal experts, and they were adamant that I was interpreting it incorrectly and saying that it's absolutely essential that it cannot be a Fulton County judge, that it's supposed to get assigned outside the county, perhaps like you said, to DeKalb or Clayton, or look at the language. Am I allowed to share the screen at all?
Yeah. I mean,
Okay.
I'm looking at a copy of the statute if you want to reference it, but
Yeah, I've
free to
got
share your
some
screen
case
as well.
law because I don't know, I'm a visual person. So like some of the case law that sharper minds than I pointed out was Williams v. Hurd, a 2017 Supreme Court decision that talks about language. Judge Boggs said, "We further conclude that because the trial judge did not meet the requirements of 523B to preside over this action upon remand, a judge meeting such requirements must be selected to preside over entry of the dismissal." I point that out because it seems to me in the case law that they're very strict about making sure the right judge is assigned. And then,
I don't disagree with you, which is why I brought it up. But
yes.
my brief review of some of the case law is that what you run into, though, is that most of those cases are internal county disputes. The one you just showed, for example, was a Baker County Board of Education case. We've had it come up in Fulton where it was, you know, 2 city council members out of East Point. But what do we do when I mean, I understand that one of the defendants that you have named is the Fulton County Board of Elections. But I'm not sure, where does it end? If 21-523 requires that it be transferred out of Fulton, then when it gets where it gets, why does 21-523 not then require that it be transferred out of that county again and again and again until I don't know where we end up?
Yeah, so I don't think it's just that it's being transferred out of Fulton. I think it's that it's following the language of 523, which is very challenging. I mean, I've had multiple discussions. So the other case law that I'd like to point out, Little John versus Cleland, Supreme Court of Georgia, 1983. The Fulton Superior Court then contacted the senior judge of the Stone Mountain Judicial Circuit, the adjacent circuit, to preside over the matter pursuant to 523. The senior judge was unable to hear the matter, so the governor's notified. Then he appoints another judge in Stone Mountain Judicial Circuit. In looking at all the case law I looked at, it appeared that they were always assigning it to somewhere outside of Fulton and somewhere within an administrative district or an administrative judge. This one, Martin v. Fulton County Board of Registration and Elections, a 2019 case. It says the case was reassigned to the 7th Judicial Administrative District. Senior Superior Court Judge Adele Grubbs was appointed to hear that case. I think 523 is obviously what controls. The clerk is supposed to notify the administrative judge for the judicial administrative district in which that county lies. Who is that person? Is that Chief Judge Glanville?
I've read that language. I think my complaint about that language is that while it provides a procedure to follow, it doesn't explain why that procedure is to be followed or the need. Now, we as lawyers, now you guys being involved in much more election litigation than I've ever been involved in, right? But the three of us, we collectively can read that to understand that probably the idea is about wanting a non-home circuit judge to hear cases involving political disputes within that county. Totally understand and make sense, but that's not actually what the statute says. And it also, if we're going to talk about that, begs the question, is if sub A says that it shall be tried by the Superior Court of the county where the defendant resides, which defendant are we talking about, and does it matter? Because as I read that, particularly as it gets to the second sentence, a contest case challenging the eligibility of two defendants, which is where I am concerned that when you read this, it doesn't just mean defendant from a pure jurisdictional perspective. It means candidate. Then does the jurisdictional issue, is it then tied to Mr. Davis and not to the County Board of Elections, which is the entity that has been sued that clearly is appropriately sued in Fulton County? That's the interplay between the two is what I'm struggling with, Ms. Oinanen.
Well, remember that the definition of defendant is defined in 21-2-520, and it's strictly says defendant means the person whose election is contested. So Jeff Davis falls under Section A, but it's also Section C and D, the election superintendent or superintendents who conducted the contested primary or election. So I'll just tell you, I called the AG and had a conversation with them, like, who's the election superintendent? Oh, well, there's a whole bunch of them. Well, there's Fulton County Board of Registration Election. I'm probably botching the name.
Oh, that's the name that you've used in the case caption. So
yeah, I think we listed two, just
two different variations of the same idea. Yeah.
We'll dismiss whatever the wrong one is, but making sure that we got, why did we pick Fulton County? Because that is who Jeff Davis, in the 132 requirements for him to run for office, he needs to be a specific elector of the county that he eligible to vote, and that's where he voted. That's where he registered, and that's in the fall of 2023, and that's where he voted on February 12th, 2024. So that's specifically why we believe that Fulton County is named as an appropriate defendant rather than naming all 180 or whatever. And then the other issue is Section D, the public officer who formally declared the number of votes for and against any question. So that is someone from the Secretary of State, someone from
which would be clearly appropriately be venued in Fulton County. Agree.
Correct. So we've got two defendants who meet the statutory definition of what a defendant is in Fulton County. And we've got one who now claims to reside in Walker County. So I think venue is appropriate in terms of Fulton, but then you follow the language of 523, and it seems very clear. Well, that's a stretch. It's not very clear, but
I agree. It's clear that there is a procedure.
Yeah.
And again, it would be a matter of, after the outcome of this hearing, if the determination is that what I need to do is I will notify my chief judge, who is the administrative judge for this circuit, that he needs to follow the procedure that would be followed here.
I'm being told that that's the case. I'm being told very strongly, like he's supposed to appoint an administrative judge from an adjoining district to select a superior court from that district. So whether that district is DeKalb, whether that district is Clayton, we like you, Judge Krause. I'm not saying we want to lose you as our judge.
Trust me, not taking it personally one way or the other.
I'm very nervous that we go through all these proceedings and it turns out somebody says that you don't have jurisdiction. And so I'd rather get this right early on. So we are now of the position, let me adjust my, the position that I sent via email.
And I understood that was an off the cuff mention. I was not holding you to that position. I just mentioned that because you had raised it, even if in passing, it was something that I looked further into because you had raised the issue.
Thank you, Judge. I admit this is very challenging language, but plaintiff is of the position that the law requires Chief Judge Glanville to select an administrative judge of an adjoining district to select a superior court judge from that district. And so that's what like I said, sharper minds than I in terms of election legal experts have suggested to me that it does not belong in Fulton County. It's not appropriate to be in Fulton County. And if it can be assigned to an adjoining district administrative judge, I think that is plaintiff's position that that is the right move.
Okay, thank you, Ms. Onanen. Can you do me a favor and take down your screen share, please?
Oh, of course. Thank you.
Thank you. Mr. Tyson?
Yes, thank you, Your Honor. So I guess a couple of things kind of to try to work through this, because I agree that the election code and the contest procedures are not built for statewide contests. They are built for local contests. So just to start with the Martin case, because I think that was the last statewide election contest that happened in 2018 to the lieutenant governor's race. That was filed in Fulton against 3 county boards of election, but filed in Fulton. And then it was assigned to Judge Grubbs as a senior judge in Cobb County to hear the case. So I think as an initial matter, yes, I have not explored, and we'd be fine consenting to you proceeding, but I think the way the statute's worded, we probably need to have at least an order directing something.
In fact, I will tell you that before we had this hearing, one of my issues was to make sure that I wasn't stepping in it just by simply opening the discussion, because subsection C is written in the directive. So
correct. Yes, I think you're right to do that. I think this does take us back, and then I'll get to A, to the kind of who is the defendant in a case. And in the Flaherty versus Poitras case, which was 263 Georgia 178, Justice Sears had a dissent where she talked about in passing, it wasn't the court talking about it, but talking about the different kind of defendants have to do with the type of contest that's being brought. And so you have a situation where if it's a vote counting problem, you would bring that against the Board of Elections because they're the people who counted the votes. If it's a candidate eligibility problem, you'd bring that against the defendant, against the candidate, because it's about the candidate. But in any case, the election superintendent doesn't refer to the secretary. The superintendent is always the county election official. So kind of from how we see things on this point, from our perspective, that Mr. Davis is really the only proper party, and I'll let the other folks talk about that if they agree or not. That's just kind of how we see the lay of the land, because it's about his eligibility, which would mean the only real proper venue is in Walker, and then we'd have to kind of go through this process up in Walker as opposed to going through it in Fulton and kind of surrounding districts and circuits in Metro Atlanta. If obviously Ms. Oinanen has sued the Fulton Board of Elections, and that does give us venue here. So I think there would need to be at least some order from the administrative judge appointing somebody from outside the circuit, I think is probably the right answer on that point. And generally, we solve it by using senior judges to kind of avoid, I think, with statewide contest in particular. As to the question about the defendant there really is about whichever of the defendants in 522, I think it is listed, or 520 is listed. And the eligibility of 2 defendants language, I think, really goes to the declared as eligible to compete with each other in the runoff primary or election.
right, and
just
I
telling
understand
you
that's unique to that issue. It's just that
exactly.
The use of it really in that sentence particularly highlights the fact that it really means candidate for that purpose. And so
yes,
that's the only reason I pointed it out. I understand it's not applicable here because no one's challenging both of the defendants or of the candidates.
Yeah. So I guess the short answer is, I think, number one, there does need to be a notification of the administrative judge. There does need to be an appointment to that purpose. But I think we kind of then are into this world where also, do we have the proper party? Because I hate for us to go through this process and then dismiss out the John Doe secretary and Fulton, and then we have to transfer Walker and kind of do this all over again. Mr. Davis voted in Walker County on May 21st. So I think that would be the venue as to him, is where he was served. So if Fulton goes out, I think we lose venue. So those are the kinds of pieces of the puzzle that I guess from an ordering perspective, it makes sense to start with getting the right judge in place from outside of Fulton, then probably secondarily resolving the proper party issue, and then kind of going through venue at that point, I think is the right answer.
Okay. Thank you, Mr. Tyson. Ms. Sleeper, I assume you're here on behalf of the Board of Elections.
Yes, we are. As for the question you asked, whether or not this should go to administrative law judge and the chief judge and to be transferred, we have no position. That it's because mostly we don't believe we're the right party for this case. It was
Well,
a
oh, forgive me for interrupting. I was just going to say, I think Ms. Oinen's point and really Mr. Tyson's is, and the reason I wanted to hash this out is that even because it's written in the directive, I doubt that the parties could consent. In fact, one case I looked at recently, in Fulton County, the parties jointly specifically filed an objection to the intention to transfer the case. And we still transferred the case. Because our understanding and our application on I don't mean to speak for all my colleagues, but generally in Fulton County, we understand this is written in the directive and it's a procedure that needs to be followed. And so the bigger concern I would have is, as Ms. Oinen had pointed out, that we would go down this road and then have to essentially start all over again once somebody figured out, hey, I'm not sure that the Fulton County Court has jurisdiction here because of the application of this statute.
correct. So, based on my limited experience with the election contest, it's always been transferred out. And that's how it's been. And we have no objection to that at all in this case. The only thing that I would like to say so that it's not a surprise later is that we are planning to file a motion to dismiss because we believe we're not the right party here. But that's about it, Judge.
Okay, and I expected that. Obviously, we've already had one from Mr. Davis. I expected there would be more motion practice. And again, before I started looking at how am I going to deal with these and are we going to do it on an expedited basis, we needed to figure out where it was supposed to be. So it sounds like the collective wisdom of the fine folks who know a lot more about election law than I do, and the application of subsection 21.2523 sub C in particular, is that for better or worse, I will notify my chief judge that this case has been filed, this election contest has been filed, and that I need for him to follow that procedure. The case will be then assigned to an administrative judge outside of the jurisdiction in an adjoining county pursuant to all these procedures. And then y'all can reach out to them to see about expediting your scheduling orders and handling your motion practice. Is everybody clear on what we're going to do next?
Yes, Your Honor.
Your Honor, because we still haven't filed our motion to dismiss and answer to it yet, and election contest is a little different in that it's not the 30-day that Civil Practice
Right,
Act
it's a much
gives.
shorter time, right? I think it's
Correct.
7 days. I can't remember.
Usually, my understanding is it goes from whatever the notice that court produces, and here, because the notice was on the scheduling conference, it is not really as the statute is written. So I guess it would depend if the court would like to give us a deadline for us to follow, that the plaintiffs would be agreeable. That would give us a little more structure. That way there's no confusion as to whether we answered at the right time or not.
Okay. Well, other than scheduling a conference, I have not taken any substantive action in this case, and I think that I should err on the side of not taking any substantive action. That would include entering any order providing timelines for people to agree for responses. Now, I suspect, given that you're here and involved in the case, and you've obviously, I'm guessing, been served, although poor Miss Oinenen, when she was trying to answer me on the fly, was like, I'm out of town and I'm waiting for mailed proofs of service. Perhaps the parties could agree to some sort of schedule in light of the situation in which you find yourselves. But it is my intention, as soon as this matter is resolved, to reach out to my chief judge and say, hey, let's get this taken care of as quickly as possible, because that procedure didn't happen on the front end the way it was supposed to, with the clerk of court and the chief judge. So I'm going to ensure that that process takes place, and trust and hope that you find professionals can figure out what to do regarding that until you get your official notice from the chief judge in the interim.
I understand. Thank you very much.
Thank you all. Unless anybody else needs anything else from me.
No, Your Honor, thank you very much. But I'm just wondering, because service is an issue, the affidavits of service have not been mailed back to us as of today. As we know, sometimes things take months. My CPA just got his Hanukkah card. I mailed him 6 months ago. So, Mr. Tyson, will you accept service on behalf of your client? Like, would you file?
I will tell you that Mr. Tyson's motion represents that his client has already been served personally in Walker County.
Yes. Yeah, Mr. Davis has been served twice actually at his home in Walker County. So we've gotten it 2 times from the sheriff's deputy.
I think though that I need to file an affidavit of service, and that's what I have not received yet because presumably they put it in the mail. So if you can provide me an affidavit, an acknowledgement of service, as long as
happy
you
to.
agree to waive some challenge down the road, you're not going to challenge service by doing that procedure.
Yeah, I'm happy to have that discussion, Julie, and we're happy to file. Like I said, I think our filing already says we were served. So I think we've already, as a matter of at least judicial notice, told everybody we have been. I'm happy to file an acknowledgement if that would be helpful.
Yeah, I just say that because your answer challenges service as a defense. So I wanted to get that resolved. And Juliana, please speak with me. I don't want you to have to write 2 motion to dismiss responses. We're happy to figure out who the proper named party is and regarding who to serve. Also, we're happy
And
to
if I could call you after, if you could
Please.
just give me your cell phone number on the chat, I will call you right
Thank
after
you.
this.
I'll give
this.
you both, since I think we're
Excellent. Well, I am going to let y'all hang out on the chat long enough to get the information that you need. I am going to say my goodbyes and reach out directly to Judge Glanville, get that in motion for you and ensure that it happens before the week is over. I'll make it happen as soon as I can, but I promise I'll make it happen by the end of the week at the latest. Thank you all for your time, and I will see you later.
Thank you, Judge.
Thank you so much, Judge.
Bye-bye.
Thank you.
Mr. Winant,
I'm going to leave
Yeah.
the Zoom open for everyone. You can just log off.
Oh, that would
when
be
you
great.
need to. Okay.
thank you.
All right. You don't have to wait
Okay.
around and tell me you're logging up. Just log off and I'll come back and see if anyone's still here. All right.
Thank you very much.
Mr. Freehoff, is the streaming turned off at least? Though I still see it says YouTube up there.
Yeah, we don't want to be on YouTube.
Thank you, Mr. Tyson. I appreciate that. I'm